All right, today we have Colorado's best attorney, Phil Harding, back with us in studio for this sponsored segment. And Phil, we're getting an inside look with you, trials and juries.
Right.
I always find this a really fascinating topic.
It's super fascinating. All my friends come up to me and they're like, "Hey, what do I say not to get off and not be on a jury?" And so I give them tips and I tell them why it's so important, right? You know, the Fifth, Sixth, and Seventh Amendment that really talks about
to be on the jury. Why it's critical to be on it.
Yes,
yeah.
it just. Look, we're a handful of countries that lets our peers decide who's right and who's wrong. It's not some elected official that says, go to jail, don't go to jail. Yes, you get this money. No, you don't. And if we have time at the very end, there was this one jury that hated me.
I'd like to talk about
but
that.
I was preventing a mistrial. They didn't know it.
Yes.
And they could never know about it.
So here's the question. What do they not know when going into a trial?
Yeah, there's a lot of good stuff, and let's talk about it. First of all, here we go. That the parties have tried to settle, and you see these numbers over here, 408. These are the rules of evidence.
Oh, so they can't be told that the parties have already tried to settle. That's
yeah, as a matter of fact, every trial, before you go, there's called an ADR order, alternative dispute resolution, which means you have to go to mediation before you can even go to trial. But under 408, it says you can't mention that there was a settlement negotiations, what was offered, any of that. The next thing is insurance, 411. So you can't mention at all that the other side has insurance and that is paying for this. So the jurors are like, man, I'm not sure if I give a big verdict, is this guy going to go bankrupt, the defendant? But there's insurance. If there's an attorney on the other side that's protecting the defendant, then there probably is. That the judge has excluded evidence, throughout it.
Wow.
And then watch out. When they start off in opening arguments, right, where the defense, and let's say it's a car accident case, they come up and they say, ladies and gentlemen of the jury, we have accepted liability. So it's all about the money. The reason why they're saying that is because once they've accepted liability, you can never know how the accident took place.
So you can't tell them. They can't know that?
Yeah, let's talk about Rule 402. Rules of evidence specifically.
Even if they ask?
Yeah, 402 specifically says all relevant evidence is admissible. Sounds right. Then it says, 403 says, if it's unduly prejudicial to one party or another, it'll be excluded.
Oh.
So the second that they've said, we've accepted liability, it doesn't mean if they can't bring in that the driver was drunk or was running from the law or Osama bin Laden's nephew or any of that, right? It's only relevant as to how much he's injured. And here's the reason why. Let's look at one of 30 jury instructions. And it says, any finding of fact you must make based upon probabilities, not possibilities. You should not guess or speculate. Now, here's the important part. You must not be influenced by sympathy, bias, or prejudice for or against either party. So once they say we've accepted liability, if you brought in that the driver was drunk, right, you'd be mad at him. Yes. The jury would be mad. So that's why
that's an influence.
That's an influence.
Can't know that.
Yeah.
Okay, so you always say juries are smart.
Super smart.
And they're going to pick up on things.
Yeah.
Tell me about that.
Yeah. Well, let's talk a little bit about this one case that I had.
Yes, and that would, that's a great way to do it.
It's a bike-on-bike accident, right? I was representing one of the bicyclists, got a broken arm, and we had evidence that the other side came out and then ran into him, right? And so the front guy was an attorney, and he zipped back in, and his buddy was behind him. So I called, out of order, the front guy who's an attorney. He's a criminal attorney. And what he said after the accident to his buddy, he said, hey, look, just call your insurance company. Let them take care of it. And I said, Rule 411, I'm calling you, but I'm telling you before you get on the stand, please don't testify that you said just call insurance, because it's going to be a mistrial. So I get up there, I'm winning, the jury's looking at me, smiling, doing all of that, and then his attorney gets up and testifies. He goes, well, that's my testimony, except for what Mr. Harding said I can't talk about. And then the jury just stared me down.
Right away.
They hated me. We won the case, and afterwards, jurors love to talk to me, and I want to tell them what's not. They wouldn't even talk to me. They put head down, they zipped out.
Because he was trying to get the mistrial.
He
knew. He was a lawyer.
Yeah, he knew I was smoking his buddy there, and then he throws that in at the end. It was
All right, Phil, thank you for coming in and talking about this. Always an important topic. You reach Harding and Associates directly. You can call them at 303-762-9500. You can also get a free consultation anytime. You can find Phil online at hslaw.com. And thanks again to Phil for sponsoring this segment.
Thank you.